If you actually care about whether American institutions still have the raw, enforceable authority to demand obedience when the person involved is a former president, you need to stop right here. Not skim, not multitask, stop. Because what just happened is not simply another episode in Donald Trump's ongoing legal drama. It is something far more structural. It is a quiet, deliberate, destabilizing move by the Supreme Court itself. The Supreme Court has just released what amounts to a judicial shockwave. That phrase might sound exaggerated at first, until you understand how this unfolded. A ruling delivered under seal, without warning, without public argument, without any visible trace on the docket, detonated directly beneath Trump's legal footing. There was no press buildup, no countdown, no advance signaling to allies or adversaries. The system moved first, and it moved in silence. Let me repeat that so it fully registers. The highest court in the United States exercised its authority before the public even knew there was a dispute. That is not normal. That is not how this institution usually operates. And when it does operate this way, it is never by accident. According to the account we're examining, this was not a procedural brush-off or a narrow technical decision. It was not a routine denial. It was the Supreme Court pulling back a veil. And what that veil concealed is the detail that rearranges everything we thought we understood. A sealed grand jury investigation that has been running quietly for more than a year, parallel to every visible Trump case, never once entering public awareness. This is where context becomes essential. The Supreme Court is designed to be transparent. Cases are argued in public. Timelines are visible. Conflicts unfold in daylight. But there exists a narrow, rarely invoked authority that allows the court to operate entirely under seal, reserved for situations where disclosure itself is considered dangerous. If the reporting is accurate, that authority was used here. That decision alone signals gravity. For the first time as described, a secret grand jury subpoena, airtight and fully sealed, moved through the federal judiciary and reached the Supreme Court without public scrutiny. Then came the trigger. A compliance deadline of 72 hours, not weeks, not months, 3 days. This is where the story stops being about one defendant and becomes about a system asserting control. By the time the order surfaced, Trump's legal operation was reportedly frozen. No preparation window, no narrative control, no strategic buffer. A legal conflict so deeply buried that even Trump's lead defense attorneys were reportedly unaware of it. In the morning, the assumption was that all legal exposure had already been mapped. By midday, the ground collapsed beneath him. Here's the distinction most people will miss. This is not just another case added to the stack. It is framed as a fourth legal front, completely separate from the classified documents case, January 6, Georgia, and the New York civil fraud matter. This ruling represents a historic inflection point that almost no one saw coming, which leaves the only question that actually matters before we go further. What was so consequential that the system kept it sealed for more than a year? And why did the Supreme Court decide that this, of all moments, was when secrecy had to end? What happens in this phase is where the story stops feeling cinematic and starts becoming structural. This is the part most audiences never really see because it requires looking past personalities and into the machinery of power itself. And once you see it, it's very hard to unsee. At the center of this escalation is a power the Supreme Court almost never uses. The court is built on visibility. Its authority flows from openness, public dockets, scheduled arguments, decisions explained in daylight. But buried deep within its institutional toolkit is an extreme exception: the ability to operate entirely under seal when transparency itself is judged to be the threat. National security, intelligence operations, circumstances where exposure could cause irreversible harm. As the ruling reportedly states, this extraordinary power is reserved for situations involving grave national security concerns. That sentence is not decorative. It is a threshold. Pause on that. When a court designed to be transparent decides that transparency itself is dangerous, the system has already shifted into a different mode. According to the account, every part of this process was sealed from the beginning. No public filings, no televised arguments, no docket trail for journalists to follow. The subpoena was issued more than a year ago under total seal, and attached to it was a gag order. Trump was legally barred from telling the public, barred from rallying allies, barred from turning the dispute into a political spectacle. His attorneys were bound the same way. This wasn't just a legal proceeding. It was information containment by design. And this is where the power clash becomes clear. Trump's political survival instincts rely on visibility, pressure, and noise. This process removed all three. There was no crowd to play to, no outrage cycle to weaponize, just courts, filings, and deadlines advancing in silence. So Trump did what he always does when institutions push back. He reached for familiar shields: presidential immunity, executive privilege, the same legal playbook he has relied on repeatedly. But this time, it failed. Not publicly, not theatrically. Quietly, step by step. First, the trial court rejected the claims. Then the appellate court did the same. Each loss happened behind closed doors, unseen, unspun, uncontested in the public arena. By the time the case arrived at the Supreme Court, this was no longer about delay. It was about finality. This is where the judiciary's tone reportedly hardened. Chief Justice John Roberts is said to have written that the subpoena targeted conduct that falls entirely outside any credible claim of presidential immunity. That sentence draws a firm institutional line between office and individual, between authority and accountability. Then came the line that signaled escalation. No further postponements will be tolerated. Read that again. That is not persuasion. That is enforcement language. And the enforcement followed immediately. A compliance order. A fixed deadline. 72 hours. Exact, unforgiving. Not a suggestion. A clock. Then came the warning. Any failure to comply will trigger immediate civil and criminal contempt, including potential consequences that may involve pretrial detention. Courts do not choose that language casually. It exists to remove ambiguity. This is the moment where options vanish. No appeals left, no procedural detours, no negotiations. The Supreme Court has spoken, and the system has positioned itself to compel obedience. Then comes the substance. The reason this clock exists at all: prosecutors are reportedly demanding 3 categories of material, each one raising the stakes further. First, complete financial records going back to 2015. Foreign transactions, loan structures, property valuations. This is not a narrow audit, it is a pattern analysis, raising questions related to money laundering, undisclosed foreign income, and potential violations of the Foreign Corrupt Practices Act. Second, communications with foreign nationals, whose identities remain redacted for national security reasons. That phrase alone narrows the scope. Analysts have speculated about oligarchs, foreign governments, or intelligence-linked intermediaries. Speculation aside, classification at this level is not routine. It signals counterintelligence sensitivity. Third, and most explosive, documents related to efforts to obtain anything of value from foreign sources connected to electoral activity. That phrasing mirrors federal campaign finance law almost word for word. Prosecutors use language like that when they are mapping statutes, not casting fishing lines. This is where the pressure fractures the defense. According to the New York Times, Trump's lawyers learned of the ruling through breaking news alerts at Mar-a-Lago. Sources described pure chaos. CNN reports that some attorneys are considering withdrawal. Politico reports that a cooperating witness has already given investigators a roadmap of what to look for. Trump's response followed instinct: attack the judges, question legitimacy, threaten non-compliance. But this is where the trap tightens. Former federal prosecutor Andrew Weissman put it bluntly: those statements amount to a written invitation for contempt proceedings. At this stage, intent does not need to be inferred. It has been declared. And when the judiciary reaches this point, it is no longer monitoring rhetoric. It is monitoring compliance. This is where the story narrows to a single pressure point. No procedural exits, no narrative escape routes, no time left to reshuffle the board. Donald Trump now stands before 2 paths, and both carry consequences he has spent more than a year trying to outrun. The first path is compliance, turning over the records, financial data, foreign transactions, communications, electoral material. If he complies, the wall of secrecy collapses instantly. Whatever he fought quietly, relentlessly, and at every level of the judiciary to keep hidden stops being theoretical. It enters the hands of prosecutors. It becomes evidence. The risk stops being political and becomes institutional. The second path is defiance, refusal, delay, partial compliance that triggers contempt. Not symbolic contempt, not a procedural slap on the wrist, but the kind of contempt the Supreme Court reserves for moments when its authority itself is being challenged. The warning is explicit. The consequences could include detention before any trial on the underlying conduct even begins. That is how unprecedented this moment is. The phrase now hanging over the system is one it almost never has to confront. A former president jailed for contempt. Not after a verdict, not after a conviction, but for refusing to obey the court. This is where the shockwave spreads outward. According to the Washington Post, Trump's allies are not just concerned about this case. They are panicking about what it implies. If one sealed investigation reached the Supreme Court without public awareness, could there be others? What else might already be moving through the system, unseen, unannounced, and far along? That uncertainty alone destabilizes every defense strategy built on the belief that all threats are visible. Public opinion is shifting in quieter but meaningful ways. According to YouGov, even among Republican voters, one core principle still holds. No one is above the law. That matters, because institutions ultimately survive not just through enforcement, but through collective acceptance of legitimacy. Legal scholars are already framing this historically. Lawrence Tribe has called it the most consequential Supreme Court action since United States versus Nixon, not because the facts are the same, but because the logic is. Power meets a limit. Secrecy meets a deadline. Authority demands obedience. 72 hours. Short. Volatile. Irreversible. So here's the question now, hanging over everything. Does a former president comply with the Supreme Court, or does he force the American system to decide how far it is willing to go to prove that its authority still holds? Before you step away, share your perspective in the comments. If this breakdown helped you understand what's unfolding, hit like and subscribe. Turn on notifications so you don't miss the most important political developments as they break day after day. I'll see you next time.